So welcome. This is our quarterly webinar. This is our last for 2021. You can find our previous recordings, tax strategies, college planning, home equity on the videos page of our website if you want to go look at those. Our next webinar is going to be on retirement planning. That's scheduled for January 2022. So hopefully you'll see an announcement on that here in a couple months. If we don't get to your question again, please feel free to contact us separately. Be glad to talk or meet with you to go over your questions. Okay, there's my information there. We're in a new office. We're very excited about that. Phone number, and we'll put this page back up at the end along with the email and the website, so that if you didn't get a chance to jot it down and you need to, it's there for you. Okay, a lot of information in this material. It's not intended for tax or legal advice. It may not be used for the purpose of avoiding tax penalties. Please consult a tax professional or a legal professional for in-depth review of your situation. Again, we'd be glad to help you in the parts that we can help with, but certainly do that in-depth detail with a tax preparer or an estate planning attorney. Neither Cetera, Advisor Networks, or any of its representatives may give legal or tax advice. So that's my disclaimer. Okay, what's the purpose of estate management? So a couple things. We want to preserve assets you spent a lifetime building. It's also about protecting your spouse, your children, and other heirs. It's ensuring that your assets are distributed how and when you want them to be. And it's also managing the amount of estate taxes that may be due after your death. There are some fundamental estate management principles that can enable you to manage your financial and personal affairs during your lifetime and distribute your wealth after death. So there's two objectives to an estate plan. The first is managing your financial and personal affairs during your lifetime. So that's one component. And the second is distributing your wealth after your death. Done well, estate management can make a huge difference by enabling you to spell out your healthcare wishes, ensure that your possessions go to their heirs that you choose, and this is really important, without endless legal wrangling, and that can cause some deep divisions in your family as well. Avoid needless expense and legal costs, and provide loved ones who may not have it the protection they need. These issues are important to trust, not to trust to others, so you need to determine the outcome in planning by planning in advance. So here's our agenda. We're going to first talk about how estate taxes work, and we're going to talk about critical documents and then tactics. So first, some fun history. Initially, estate taxes were used as limited term taxes to fund wars. So you had the undeclared war with France in 1797, Civil War, 1862 started, and then the Spanish War of 1898. So it wasn't until 1913, the 16th Amendment to the Constitution was passed that gives Congress the right to, this is certainly a good term, lay and collect taxes on incomes. They got a broad license there on whatever sources derived. So in 1916, the Revenue Act was established to create estate taxes. It's been modified over the years, but never repealed. In 2012, the American Tax Relief Act made estate tax a permanent part of the tax code. Then in 2017, the Tax Cut and Jobs Act doubled the estate tax exemption to what it is today of 11.7 million. Very important, this law is currently set to expire December 31st, 2025. And I'll mention that a couple times so that you're aware of that. Okay, the next section is, we're going to spend a little bit of time on this. This is just to give you a quick way to calculate your estate taxes. Now, people will say to me, Chris, I'm never going to have $12 million in my estate. Well, let's not be so quick to say that, because when you include all your assets plus death benefits from insurance proceeds, and that's the one that people many times forget, it could easily get up to several $1 million. And the other thing is to remember is, I just told you that estate tax is set to expire. So I suspect that many future administrations will change that for their own benefit, up or down. So it may be that it does impact you, in the future, whereas it may not now. So for example, let's just say your estate is $12 million. So we're on the left side looking at the federal formula. The exemption right now is $11,700,000. So that would leave $300,000 of taxable income, taxable assets at a rate of 40%, giving you a total estate tax of $120,000. So that's just federal. So Maryland's quite different though. So Maryland only lets you exempt the first 5 million of your estate, which in this example would leave 7 million taxable at a capped out rate of 16%. So $1,120,000 of Maryland estate tax. So the moral of the story is retire and move to a lower tax state, right? Just kidding. That may be the answer for some of you, not if your family's here, obviously, but that may be the answer. The other thing about Maryland is they have an inheritance tax. So if you leave any money to what they call collateral heirs, niece, nephew, friend, so not a direct line heir like a brother, sister, mother, father, son, or daughter, they incur another 10% tax. So again, that's something you want to think about and manage accordingly. So keep in mind that one thing to remember is that the federal exemption is indexed right now. So that 11,700,000 could go up with inflation, but the Maryland one is not. It's capped at 5 million. Again, so you may be thinking this might not apply to me, but keep in mind, we have to include the death benefit from insurance proceeds. And remember that the federal exemption is going to expire in 2025. So it may impact you in the future. Here. Sorry about that. There was something blocking my slide here. Let me just go back and finish one thought. Okay. All right, got it. All right. There are a number of critical documents you may need to have a part of your estate plan. The first of these is a will. A will is the most basic estate planning document. A will tells the world exactly where you want your assets to go when you pass away. Everyone should have a will, but according to one group study, only 60% and 67% of Americans don't have one. So it's really short-sighted. It's not just for the wealthy. Every individual who dies intestate or without a will, the state will decide. Okay. So for example, in Maryland, what that means is if you die without a will is that 50% of your assets go to your spouse, and then the rest of the 50% go equally to children. So that might not be what you want. That might not be your plan. So that's very important that you set up the will. Keep in mind as well that any asset with a beneficiary, i.e. a 401k, IRA, life insurance policy, they all pass outside the will. They pass according to the beneficiary designations that you have. So even if the will is different, the beneficiaries in those documents will supersede. So got to keep that in mind. So what's a reason that my beneficiaries might not be up to date? Well, there might have been a marriage since you originally constructed the document, or there might have been a divorce. There might have been a passing of a beneficiary. There might have been a beneficiary whose maybe their financial circumstances have changed and really they don't need the funds. It would be better used to give to a sibling. Or maybe you want to add a charity to your benefit that it wasn't in there before. So several reasons why you might want to review those. So what does a will do? It lets you name an executor. So that's someone who follows the wishes of the will. And it lets you name guardian for children that's important as well. Also directs how property is distributed. But here's one big negative. It goes through probate. So we want to keep that in mind. That could be a real shortcoming. That could be a real limiting factor. So that means a will can be contested. In fact, the probate court will send out a notice to anyone who might have grounds to contest the will. And if someone wants to contest it, there could potentially be a long battle in the court. Because a will is essentially instructions to the probate court of what you want to be done with your assets. So I would say expect a will to go through probate. And again, public process, you may or may not want those your wishes to be made a public record. If a will is the only estate management tool that you use, anyone who can and wants to can find out what's in the will, how much you left and to whom. Okay. Again, that may or may not be important to you. We can talk about more how you can potentially avoid probate and distribute your assets to heirs privately. One of those answers, and we'll talk about shortly, is a trust. But first, there's some essential documents that most people should consider and have in place. Okay, so let's look at these. Critical documents on the healthcare side: a living will and a durable power of attorney for healthcare. So if you become incapacitated, the durable power of attorney would direct, that document would direct the healthcare professionals who to go to make a healthcare decision, surgery, care, what have you. And then who would be the contingent person to do that as well. Financial documents, some of that can be solved with joint ownership. Some of it can be solved with transfer on death documents. We use those here whenever we have a brokerage account, a single individual, or sometimes we can do it for a joint account too. We set it up. So again, remember, those pass outside the will. Durable power of attorney, and of course, a living trust is another example. On the healthcare side, you have a living will. So living will comes into play an end-of-life medical care. So it's been determined that your life is going to end soon. It's soon going to be a passing. What kind of measures would you want to provide you comfort and support before that happens? That's described in the living will. Then there's the durable power of attorney. So the durable power of attorney, again, authorize someone to make a healthcare decision on your behalf. So that's important that that person is near you, hopefully, and willing to take on that role. And then you also have a contingent in place as well. Keep in mind that in Maryland, they only have durable power of attorney. So it's assumed it's a durable power of attorney unless stated otherwise. An example of use is a regular power of attorney. Regular power of attorney ceases at incapacitation, whereas a durable power of attorney ceases at death. So two very different documents. But in Maryland, they are typically durable power of attorneys. So I just got a question from John. Can a person receive, and I'll just say payment for executing the role or being the executor of a will? And yes, that can, as long as it's reasonable. That language is usually put into the will, and so that's how that's handled. Okay. So, what would your family want to know if you were to become incapacitated? 70% of research shows that older Americans complete advanced directives before their death. So that's very helpful. That's about a 30% improvement over a decade ago. And here's the thing with life expectancies, well, they kind of come and go right now, but typically they are continue to extend and more treatment options are available. It's really important that these your directions, your wishes are spelled out. So everybody knows what what's in the advance directive and how to fulfill those wishes. Okay, financial documents. So again, we talked a little bit about this. There is joint ownership. So that's one way of managing your estate. Okay, so joint ownership typically is joint rights with survivorship, joint tenants with rights of survivorship. So that means that in case of anyone, typically it's a husband and spouse, they each own 100% of that asset. So husband passes away, it's now 100% the wife's account. Vice versa, same thing. It doesn't have to be husband and wife. It can be, sometimes it's a mom and a daughter. You know, mom's maybe her cognitive abilities are starting to diminish, or she just wants to know that someone else is on the account that can make decisions. Again, assets with beneficiaries, we talked about them. So they all pass outside of your will. So it's important that you review those from time to time, and that's a service we can provide, help you with that, just to make sure that they are current, up to date, and your wishes are clearly stated. Durable power of attorney, again, works in the case of incapacity, and then living trust would be something that you could use in lieu of a will to spell out your wishes for your assets and for the care of your assets. Okay, so what about other ways to get rid of assets? Not to get rid of assets, but to trim down your taxable net worth. So estate management isn't the only tool. There are some basic tactics you can understand and use as well. First off, simply giving money away. So each spouse can give away $15,000 per person to anyone they want to, okay, over the course of a year. And that doesn't have to get reported. That doesn't have to be, that's not taxable to you or to them. It's just considered a gift. If you give over 15,000, you are taxed on the amount that you give over that, and you have to fill out the proper form. Each person, each individual has $11,700,000 that they could give away without being taxed on it. So a couple could effectively double that. So I think that will take care of most of us, but that is something that you can do. And I really like helping clients with giving plans. That's really a fun part of our job, that we do together, hopefully a good job on the planning, and we have some spare capacity to give. So we really like to talk about that. Okay, trusts are another powerful tool. So we talked about wills. We saw the value of the will. The will is about so for a couple, it's probably a $1,500 cost for a couple to do a simple will, medical power of attorney, financial power of attorney, and a living will. A trust is a much more involved product, and so it's going to cost a little bit more. Typically, it's going to cost about $2,500 to $3,500 per person, but it does give you some features that aren't in a trust. In a will. So, for example, you avoid probate. That may be really important to some folks. You know, you don't want your assets and how you distribute those assets to be a matter of public record. So that could be really important. Effective management and distribution to the heirs. You can do more management tools with a trust than you can with a will. And, you know, set an age limit, certain percentages. Maybe you want to wait to certain ages of maturity or different life events happen, say a marriage, a house, graduate from college, whatever those might be. So those can be in there. So you have control, a little bit of control of the beneficiaries, because a trust is a living document. It can own assets, just like a person can own assets. It is very difficult to contest, and it's effective immediately upon the signature. So even though a will is effective upon the signature, it actually doesn't come into play until there's a death, whereas a trust actually can start owning assets right away. So that's why I mentioned that, that component of it. So again, a trust is a legal entity. It owns property. You know, you certainly want to, if you want to set that up, get with an estate planning attorney and someone who understands all the rules and regulations and make sure it's set up correctly and the language is correct on that. Okay. Let's make sure we don't have anything else. All right. Okay, what do you need to consider when putting together a management plan for your estate? Well, there's two crucial factors. So especially in regards to the trust. I mean, a lot of this is same for the will as well, but more specifically for the trust. So first off, what's the value of your estate? So keep in mind your estate includes everything on the left side there: personal property, home, real estate, cash, investments, retirement plans, business interests, and life insurance, the cash value of life insurance, but also the death benefit from the life insurance. Okay, very important, because that could really send your estate up to a much higher number. Keeping in mind again that on the federal side, until it exceeds 11,700,000, it's not subject to estate taxes. So you may not want a trust, necessarily need a trust for estate tax reasons, but more so for managing of the assets, the distribution of the assets, that maybe you have a more complicated situation. So a good example would be a second marriage. You know, there's a second marriage, and basically you're taking care of your kids. He's taking care of his kids, and so you want to be a little bit more descriptive in that, how that works out. And so that would be a way, one reason for a trust. So for example, I have a trust, and so the Holcomb family trust owns my home, and it owns my brokerage account. Okay, so one of the things that people forget about when they create a trust is retitling the assets to the trust. So if you don't retitle the assets to the trust, then it's basically just a description of what to do with your assets. Whereas if you really want to use the power of a trust, you retitle assets that are appropriate for being in a trust, like the example I just had, the Smith family trust, the Holcomb family trust, etc. And that way they are now in the trust and more protected than they would be otherwise. So let me give you some other examples about trust. So this is some things you can do with a trust that you might not have thought about. Whom do you want to inherit the assets? Okay, whom do you want handling your financial affairs if you're incapacitated? Whom do you want making special decisions for you if you become unable to make them for yourself? You want to provide for your spouse if you should die first. You have young children to provide for. If your children are grown, do you want to distribute your estate equitably? If not, what way would you like to distribute them? Will you need to provide cash to help your heirs sell your estate? A will can help accomplish some of these objectives. So I recommend, again, you discuss whether a will or a trust is more appropriate for you and your situation. Okay, so let's talk about a tool that is used to help pay taxes or provide assets. So you can own, and I'm just going to use the cursor here, you can own a irrevocable trust. All right, an irrevocable trust, you would fund it, put in whatever amount you need to buy a life insurance policy. And the purpose of this is to pay estate taxes. So if you think you're going to be in a situation where your estate's going to be over 11,700,000, this is a great way to get those estate taxes paid for outside of your estate. Okay, now I know again that number seems like a big number, but it's going to get changed. I'm very certain of that different administrations will change it. It seems to be a very likely target for tax law changes. So this might not be a strategy for you right now, but certainly could be in the future. So again, you take assets, fund the trust, And with the trust, it buys life insurance, hopefully sufficient life insurance to then pay the estate tax bill that's yours. Okay, so now we have a trust in place. There's a death. The assets, the death benefit from the trust go to pay the IRS, whatever estate taxes are due, and then the rest would go to the heirs. Of course, the assets would go to the heirs directly. They wouldn't necessarily, there's no reason for them to go to the trust. So just a couple of things to keep in mind about this strategy. One is you have to be insurable, so this is an insurance product. You still have to go through underwriting. You have to get approved. So that's really important if you think you're going to use this. The other thing is there are several factors that could come into the cost and the availability of life insurance. Obviously, age, health, type of insurance you provide. Certainly, you'd want this to be a permanent policy, like whole life insurance or universal life insurance, because you don't want something that's going to expire before you pass away. Life insurance has expenses that include mortality and other charges. If the policy is surrendered prematurely, i.e. term insurance, you'd have to pay surrender charges, potentially income tax implications. You consider determining whether you're insurable before implementing the strategy, certainly very important. Don't want to go to the cost of adding a trust until you know you're insurable. And again, any guarantees of the product are based on the insurance company's ability to pay. And life insurance is not insured by the federal government, banking or saving association. So there's some things to think about in this strategy, but can be very effective if you fall into that category. Now, keep in mind too, we don't want to just think about federal life insurance. We want to, estate planning taxes. We also want to think about the Maryland tax. The Maryland tax is a much lower threshold. So maybe you don't do this to manage Maryland federal estate taxes, but you do it to manage Maryland estate taxes. So again, something to think about. Okay. So what do you need to consider when putting together a management strategy for your estate? So there's two critical factors. First off, what's the value of your estate? So we already talked about this. It's the accumulation of all your assets, any ownership you have in real estate, in businesses, the death benefits from your life insurance, of course, your accounts that you have, including the accounts you'd have with us, and that sort of thing. And then your management objective. So in a will, you have a limited amount of ways you can manage it. In a trust, you almost have unlimited ways that you can manage it. Of course, it just depends on how much you want to pay for all those options. But again, best talked about with an estate planning attorney. So just remember, who do you want to inherit the assets? Who do you want handling your affairs? Who do you want to help if you become incapacitated? Who do you want making medical decisions for you? If your spouse was to die first, that would change some of these decisions. Who do you want to care for young children, et cetera, et cetera. So all of those things need to be taken into account. I hope we gave you a lot of good information. I hope you found this talk helpful. What we'll do now is take some questions, and I will try to answer them the best I can without getting too far into legal or tax advice. So again, the best way we can help you in this process would be assist with the beneficiary review. So many folks have never gathered all their insurance policies and accounts that have beneficiaries. So that would be work policies, insurance policies. That would be policies that we have with you, policies that you've maybe started before we started working with you. Certainly going to be IRAs, SEP IRAs, 401ks. It is a very helpful process to pull all those documents, all those policies and accounts with beneficiaries, and sit down with a professional like myself and just walk through them. Does this still make sense for you? Is this still the best solution for you? Again, keeping in mind that maybe one was created when you were single, now you're married, maybe there's a death, a divorce, maybe there's children, in different places, maybe you want to add charities, etc. So that's the best place where we can help you in this process. And for more in-depth questions, you'd certainly want to get with a an attorney or a tax preparer. So estate planning attorney, you want to prepare the will, prepare the power of attorneys, prepare the living will, prepare trust documents, etc. I really appreciate your time. Again, feel free to connect with me on the phone or email. If you heard something, you want more clarity or want more, more question, I'd be glad to do that. We certainly enjoyed having you guys. Hopefully many of you can join us again in January when we do the retirement seminar. Have a great day.